on supplementary list for final sole item 2, second appeal to 121 of 2022.
Sorry? We have appeared, we also filed the Vakalatnama, but it is not showing in the record. Now,
you have filed Vakalatnama?
we have filed Vakalatnama. Was taking that, it may be taken on 2 weeks. Meanwhile, leadership may direct that scan copy of the record.
No, that is always available to you. I don't know, sir.
The office insists that I get permission from the
No, you must be having your own copy. Your client hasn't given you the records. Your client hasn't given you the records.
Some of it gets strained during the
When it comes for the parties are present, इनको scan अभी दे दीजिए. जाइए पेन ड्राइव लेके आइए. कहाँ है? दीजिए इनको. Also for the respondents. 1, 2?
1, 2, 3.
What about 4? Only 1 to 3? Okay. Counsel for the respondent seek adjournment to prepare himself to argue this case. Post this case on next Thursday. Final disposal. No adjournment will be granted on the next day. Adjournment.
Item 3, second appeal 244 of 2023.
Final disposal.
Okay.
Yes, please. हाँ है अपना.
Mr. A.K. Sani is that in the discussion?
कोई बात नहीं हम लोग पढ़ नहीं NCR में.
Bit 3 lordship may kindly see.
Give us certain foundational facts for a timeline.
Lordship, plaintiff filed a title suit for a specific performance of contract lordship. Suit was decreed. Thereafter,
Just a specific performance of contract, right? Contract dated?
lordship.
Let us see the nature of relief.
Yes. Internal page 8 of the plaintiff's lordship.
You have to see it from the plaint or you can see it from the decree. Trial court decree?
You may also lordship may kindly see the plaint lordship. Para 26 lordship. Page 8 of the plaint.
The proceeding was ex parte.
No. After hearing the party lordship, suit has been decreed.
Just a moment. Para 8 of the plaint, right?
Para 26 lords. Relief portion lords.
Before.
The plaintiff therefore pray the following reliefs. Your lordship got it.
Just.
A decree for a specific performance agreement for sale dated 27 for 2006 in so far as defendant number 1 untransferred share of 38.5 decimal of land of Schedule A is concerned, directing the defendant number 1 to transfer 38.8 decimal of untransferred land, being the residue share of the defendant number 1 in Schedule A in favor of the plaintiff or their nominee Janardhan Prasad in terms of agreement dated 27/4/2006, read with agreement dated 1/4/2008, or in important law, say, or in this case the learned court is of the opinion that agreement dated 1/4/2008 is not sublimate to public part or extinction of the agreement dated 27/4/2008, rather a separate agreement, then the decree for a specific performance of agreement dated 1/4/2008 may kindly be passed in favor of another performer dependent number 1 by their transposing him as plaintiff or otherwise also. Thereafter, lastly, the issues were framed, but he did not raise any objection.
No, on refusal or failure of the defendant number 1 to execute the sale deed transferring restitution in favor of the plaintiff and stood for pro forma defense.
Such deed may kindly be executed by
Why in favor of Janardhan Prasad?
Janardhan Prasad is a relative of the plaintiff lordship.
Okay.
Therefore, lordship the relief was claimed last.
That's right. Now, this was the relief rate. Now, give us the agreement.
Agreement is 27/4/2006.
27/4/2006. Exhibit.
That is exhibit 1.
Let us see exhibit 1.
I don't have the copy of the exhibit 1 lordship. I also see the record lordship that there is no exhibit 1 lordship. Maybe I am wrong lordship.
Oh, exhibit is there.
Exhibit is there.
Yes, of course it is there.
I don't have the copy of the exhibit.
So,
Yes. I have, sorry. I have, sorry. Yes, exhibit 1. May I read lordship?
yes, who are the parties to this?
Parties is the appellant. Appellant and his partner
Sorry,
lordship.
madam. Number serial such के folate sir. दूसरे को. Now, madam, only one thing I may permitted to submit to lordship.
Okay.
Your lordship would find that the suit was filed for a specific performance of contract. For in respect of an original agreement, that is exhibit 1. Now, this second prayer which has been made, that exhibit 1 by 1, that is agreement dated 1/4/2008. If it is found it is in addition to the previous agreement, then the learned court may proceed accordingly. That is the relief what I have
That's
yesterday read. And then, my lord, then the direction upon the defendant number 1, the appellant is the defendant number 1. There are 3 sets of defendants. Defendant number 1, the appellant. Defendant number 2 is partner of the defendant number 1, but in the matter of purchase of the property through debt recovery tribunal. So he was the partner. So joint agreement between defendant number 1 and 2 one hand, and the respondent number, the plaintiff respondent in the other hand. This is the agreement block 27/4/2006. And the second agreement is 1/4/2008. 1/4/2008. That is in between the plaintiff and the defendant number 1. Second agreement. In between there was another document, that is Panchanama, which they same. There are 2 documents. Those are exhibit 3, the deed of disclaimer, which they are harping. Deed of disclaimer.
What is the
That
date?
was
That is
exhibit.
also 1/4/2008.
Yes, that is 1/4/2008. That is exhibit 3. And another document is the Panchanama,
Exhibit.
exhibit 2. Exhibit 4. Exhibit 4 Panchanama. So the Panchanama is the basis of exhibit 1 by 1. Now, if your lordship may kindly appreciate, which are not in dispute, the total area of the land is 98.8 decimal. 98.8 decimal.
Just a moment.
And
नहीं ऐसे नहीं
हम बता दो
आप
फैक्ट
सीक्वेंस बताइए, आप सीक्वेंस नहीं बता रहे। डीआरटी में कब ऑक्शन हुआ,
वो बता
कब पैसा
नहीं,
हुआ,
उस समय dispute
कब ये
नहीं-
एग्रीमेंट हुआ।
dispute नहीं
डिस्प्यूट नहीं है, लेकिन फैक्ट के बिना तो कैसे पता
अच्छा,
चलेगा,
तो
दिस
ये-
बैकग्राउंड के बिना नहीं पता चलेगा ना केस का क्या है।
तो पांच छह डेट है
हाँ,
वो
हमको
नोट
डेट
कर
बताइए। What was the date of auction in?
नोट करा
Who was the auction purchaser?
Yes.
He asked for money from whom? कौन
सब
पैसे
हम-
दिया, वो
सब
सब
हम
सीक्वेंस
नोट करा-
बताइए, उसके
एकदम
बिना हम
serially
जजमेंट
नोट
नहीं
करा।
लिखा पाएंगे।
आरपी केस नंबर 170 by 2002 Before the-
170 by 0.
170 by 2002 that is the subject matter of the land was put in auction. Then Lord your lordship will kindly see the defendant number 1 and 2 are the auction purchasers. Defendant number 1 and 2.
Okay.
For rupees 10,75,000. They paid rupees 2,50,000, and for rest amount of rupees 8,25,000, they were in search of some person to help them, and ultimately that agreement was arrived between the plaintiff and the defendants number 1 and 2, that is on 27/4/2006.
There are two plaintiffs.
Plaintiffs. Agreement dated
Plaintiffs and
the defendants number 1 and 2
defendant number
on 27/4/2006.
on
Exhibit 1.
24, sorry,
27 2006.
2006.
Exhibit 1.
Exhibit 1. What is the nature of agreement?
Agreement. To sell the entire property which they were to receive from the DRT, that is 98.8 decimal, for rupees 19 lakhs, out of which admittedly 9 lakhs, 8,25,000 and 25,000 additional cost, 8.50 lakhs was paid by the plaintiffs to the DRT on behalf of the defendants number 1 and 2.
8.5 was paid.
8,500.
नहीं 8.5 नहीं हो सकता है,
8,25,000
8.25 था।
उसके अलावा 25,000
Bondage fee वगैरह।
एडिशनल कॉस्ट लगाना है,
ठीक है।
तो वो दिए हैं, हम उसको डिनाई
हाँ,
नहीं
ठीक है, admitted है। 8.5 lakhs was paid.
by the plaintiffs
हाँ, yes.
to the DRT,
Yes.
and that is payment to the defendants number
That's
1
right.
and 2. There
That's
is
right.
no
On their
dispute.
behalf. Remaining कितना होगा?
रिमेनिंग वो जो 19 लाख में वो 9 लाख को दे दिए और
10,50,000।
10,50,000 रुपये उनको देना था। उसमें से प्लेंटिफ उनका और कहना है कि 3 लाख रुपया डिमांड ड्राफ्ट से वो पेमेंट किए हैं, 3 लाख करके 8 डिमांड। Yes, plaintiff paid rupees 5,25,000 by several times to the DRT, वही 8,25,000 का हिसाब हो गया, उसको हम नहीं जानेंगे।
ये 10.5 लाख में से कितना रिमेनिंग था?
उसमें इनका जो अपना केस है 23 डिसमिल एडमिटेड है, 23 डिसमिल जमीन जो है रजिस्ट्री हो गया डिफेंड नंबर 1 and 2 के द्वारा इनके फेवर में।
23 district.
Yes, there is no dispute.
Just a moment. Sold by
डिफेंड नंबर 1 and 2
दोनों की एक
जी, दोनों
किया
मिलके,
था, दोनों मिलके नहीं किया।
हाँ दोनों मिलके
Number 1 and 2
1 and 2
sold
23
to
डिसमिल
plaintiffs
इन बिटवीन 18/9/2006 to 6/10/2006,
18/9/2006
18/9/2006 6/10/2006
by registered deed.
by registered deed.
Okay, what was the remaining land?
अब रिमेनिंग रह गया आपका हुजूर 98 से वही
रजिस्टर्ड डीड का कोई डेट होगा ना?
38%।
रजिस्टर्ड डीड
98
का
से
रजिस्टर्ड डीड का कोई डेट होगा ना?
इन बिटवीन बता रहे 4 डीड हुआ है।
अच्छा 4 डीड्स।
हाँ 4
अच्छा।
डीड से दिए हैं।
ठीक।
उनका अपना केस है।
4 registered
6 से 6/10/6 देयर इज नो डिस्प्यूट।
Okay.
तो रिमेनिंग रह गया हुजूर 76 डिसमिल के आसपास।
98.8 minus 23 decimal,
हाँ।
right?
तो 75 डिसमिल समथिंग 76 के आसपास। So 75.8.
75.8 is remaining.
Yes. Now, thereafter, dispute arose. According to the plaintiff, the plaintiffs have paid the amount of rupees 15 lakhs 21,000.
15 lakhs क्यों होगा? 19 lakhs में से
वही
remaining
4,29,000 ड्यू। 4,29,000 ड्यू।
टोटल पेड अमाउंट कितना है?
1521.
15.21 lakhs.
जी। Now
ड्यूज कितना हुआ?
4,29,000.
4,29,000.
अब हुजूर
एक
4,29,000
सेकंड, this 4,29,000 is for the entire 98.8 display.
यस रिमेनिंग। तो रिमेनिंग लैंड के लिए क्या किए ये 4/10/2007 को इनका केस है जो डिफेंड नंबर 2 को ये सारा पैसा दे दिए 4,29,000
जो इनके पार्टनर
आप बीच में मत बोलिए अगर हम गलत बोलते हैं एक भी डेट गलत बोले तो क्वांटिटी
ऐसे देखिए फैक्ट्स बहुत कॉम्प्लिकेटेड है। पार्टनर है
Confusion
तो
हो जाता है
पार्टनरशिप
हुजूर।
डीड थोड़ी है।
बीच में इंटरप्ट करने से कंफ्यूज कर जाएगा हम
4/10/2007
इनके सहयोग नहीं है हुजूर हम कंफ्यूज कर जाएंगे
4.29 lakhs
जरूर बोलिए
was paid to
the defend number 2
defendant
and not only that he
2,
got
that is Chakravarti.
yes not only that he got 4 sale deeds for 70 the rest area registered sale deeds in their name.
Okay. For the remaining area?
Yes, it has been executed.
Sale deed of remaining area.
Yes, has been executed by defend number 2.
Executed by
Defend number
defendant
2.
number 2. ये किस पीरियड में हुआ?
Exhibit 2007 में.
In the
And that
year
is 4/10/2007.
on okay 4/10.
Now, what land is to be executed by defend number 1? The dispute arose that entire money you have paid to defend number 2. Then a panchayati was held. In panchayati, one criminal case was earlier lodged by them against the defend number 1. Then it was agreed that he will withdraw that case and the 50% of the amount which has been paid to the defend number 2, he will pay the defend number 1. And in such case, then the matter will be solved.
Just
And therefore,
just पंचायती में क्या हुआ? Defendant number 2.
defend number 1, 2 and plaintiffs सब कोई पंच में बैठे.
ठीक है, सब defendant number 2 would pay 50%.
2,25,000.
2,25,000.
4 लाख
इसका 50% of
50%. 4 लाख जो दिए थे उनको
50% of
4 लाख
4.29.
हाँ 4 जो भी है 4,29,000 का आधा.
4.29 to defendant number 1,
Yes.
and then defendant number 1 would execute the
Not necessary. Already entire land have been executed.
नहीं, वो बात ठीक है, लेकिन he is not the sole owner of the property.
Yes.
ना?
Now the
There were two owners
now
of
the
the
question
property, joint
remains.
owners.
Now this is my submission for lordship. On the date of suit, is there any land to be executed? Once the land has been purchased by them from defend number 2 entire area, how the defend number 1 will be able to execute it?
See, the point is
It could have been
that
confirmed.
defendant number 2,
So it could have been a registered deed for
whatever confirmation or
But
execution
now
or
you're
some
not-
deed was to be executed.
Now, yes, no deed was to be executed for sale deed.
No
It cannot be a
confirmation.
sale deed. It cannot be
Whatever,
a sale deed.
whatever be the nature
Now,
of
this is the
transaction.
point. Now, your lordship may kindly appreciate for a moment. The 1/4/2008. It is an agreement for disclaimer. Disclaimer means
There are two documents. One is Exhibit 3.
Panchayatnama.
Exhibit 3.
Yes, Exhibit 3 is the disclaimer.
This is
And
relinquishment.
another
deed.
Exhibit 1/A is the agreement. Now, what is the agreement and what is the disclaimer? Your Lordship has to see these two documents in order to appreciate.
Now let us see.
Now, I am just putting a question to myself. If your Lordship may kindly read the relief sought for, and that is the reason your Lordship on that day, on the date of admission, I have read the relief and narrated the fact. Your Lordship has been taken pain to quote the reliefs in the order while admitting this appeal. Your
Yes,
Lordship
yes,
may
we have
kindly,
seen it.
your Lordship has seen it. Now, where is the relief for cancelling the deed? 4 deeds in respect of the remaining area executed
There is no
between the plaintiff and defendant number 2. And in absence of cancellation, now how the defendant number 1 would be asked by the court of law to execute the same cell deed for the same area which they do not have for any reason, and to execute that to specific performance of that contract. That is my submission. And this point was raised not only here but also before the learned court. And what has been the reply of both the learned courts? I will read from the judgment.
What was the,
No relief.
just a moment,
Yes.
what was the agreement dated
Yes.
1/4/2000?
Yeah, you know, see, just see for 1 by 1, 1 by A, exhibit 1 by A.
Exhibit 1
Then
by
it will be
What
clear.
was the agreement about?
Yes. And exhibit 3, both the documents. The Lordship may kindly permit you to refer to exhibit 3 first, which is the date of disclaimer. Whether the terms of that disclaimer, whether the document can be read in isolation or it can be read as a whole, as per law. The Lordship may kindly see for a moment. Deed of disclaimer is exhibit 3.
Yes, exhibit 3.
Yes. Exhibit 3 mirror.
Hmm.
Deed of disclaimer is made on this 31st March 2008. Actually, Sahi Wahajur Ekchar 2008.
Ah.
Now, your Lordship, just come to. This is executed by the defendant number 1 and 2. Defendant number 1, that is appellant. Appellant before Lordship. Your Lordship, just turn to page 2.
By defendant number 1.
Yes, by the appellant. Now, page 2 का जो second paragraph पढ़ा है, first paragraph. I and Chandan Chakraborty had jointly received rupees 15,21,000. There is no dispute. Out of rupees 19,50,000 from the purchasers, which was duly done and acknowledged by us. Rest dues of rupees 4,29,000 has been duly received and acknowledged by my partner Chandan Chakraborty, 4/10/2007. No partnership deed. Whereas, owing to some legal and personal problems, I could not come to registry office for execution of registered sale deed in favor of Janardhan Prasad and Srimati Indu Devi. Hence, the sale deed in favor of these persons was executed by Chandan Chakraborty. Sale deed number 4 sale deeds जो हुजूर बोला 4/10/2007. Although I have received rupees 7,60,500 out of my share, rupees 9,15,025 of the highest consideration, that is 19,50,000, and rest 2,45,000 is lying with my partner Chandan Chakraborty, which will be paid to me by Chandan Chakraborty at the time of execution of registered sale deed in favor of Janardhan Sajan. Whereas it was my legal obligation to maintain the sanctity of the sale agreement dated 27/4/2006, I could not maintain the same. Now I hereby agree to execute any registered document in favor of Janardhan, any registered document in favor of such and such in such any type of litigation which may raise in future regarding such and such. Now,
That's right.
I
And where
further
is exhibit
declare I will
1?
never raise any claim.
That's right. In
Now,
order
now,
to
now your Lordship
cover
may-
up the entire situation, this kind of arrangement
That
was
has been
made.
settled. Now, It is settled on the immediately another document exhibit 1 by A.
Yes. What
The
is
next
it?
document.
Yes.
On 1/4/2008
Yes.
by the appellant and the plaintiffs. Now, Your Lordship may kindly see for a moment what is the basis of that document. Your Lordship may just see third paragraph,
Just one. Please open.
second page.
Who are the parties to the settlement?
The appellant before Lordship, no?
Exhibit 1 by 1.
1 by A,
Appellant is within our party.
the appellant and the selling-
Appellant would be defendant number 1.
and Janardhan Prasad,
The purchaser.
purchaser, that he is the another part.
ठीक है.
Now, Your Lordship may kindly appreciate for a moment the
It is between defendant number 1 and the
Sasi
purchaser.
Kumar Bharma is the plaintiff and just see the who are the plaintiffs. Sasi Kumar Bharma and the respondents here is Rajesh Kumar Bharma.
Who are they?
They are the plaintiffs. You will also
And
just
the
see.
purchaser is Janardhan Prasad.
Yes.
As per the agreement.
Therefore, now I am coming to that. I just point out on that.
Huh.
Now, it is between the exhibit 1 by A, what I was referring to.
Hmm.
You know, just see for a moment.
Is between defendant number 1
And Janardhan
And-
Prasad.
defendant number 3.
Yes, defendant number 3. Now,
And not with defendant number 1.
not the plaintiff,
Not neither the plaintiff nor the
not the
defendant
defendant
number
number 2.
Performer defendants.
Defendant number.
Neither defendant neither plaintiffs
Nor the defendant number 2 are parties to this
nor
agreement.
defendant number 1 and 2. 1 भी तो नहीं है.
One तो appellant हो तो वो तो अपने हैं party.
हाँ हाँ yes. Defendant number 2 भी नहीं है.
Plaintiffs and defendant number 2.
2 नहीं है.
Now,
It is between the defendant number 1 and defendant number 3.
now I am reading here. I, such and such vendor, along with one Chandan Chakraborty, seize and possess 98.8 decimal of land in Moja such and such, acquired white certificate of sale, RP case number इतना 13/6/2006 by the learned such and such. Whereas,
ये नहीं समझ आ रहा.
हुजूर, ये जो लिख रहा है,
ऊपर नीचे deed of agreement between first day of April 2008.
हम उसके बाद सेकंड पेज पढ़ रहे हैं. सेकंड पेज.
Second page, Shri Janardhan Prasad.
यस,
Then,
उसके बाद सेकंड लगा.
whereas,
यस, वही पढ़ रहे थे.
हाँ,
The appellant is Hidanand Bharti.
हाँ,
The vendor, along with one Chandan Chakraborty, owns and seize and possess 98.8 decimal of land, such and such, being acquired white certificate. This is the source of acquisition of the land. कहाँ से मिला, कितना जमीन है,
हाँ,
उसको हम छोड़ देते हैं. There is no dispute.
not this one.
While in possession over the said land, aforesaid Chandan Chakraborty sold 2.55 decimal of land by virtue of registered sale deed 4/10/2007 and 24 decimal of land by virtue of registered sale deed इतना चारों sale deed का वजूद description दे दी.
ठीक.
4/10 भी fact है. Whereas the vendor has expressed his desire to sell his share of land, 38.5 decimal of land more fully detailed and described in the schedule below, and the purchaser has agreed to purchase the same for a valuable consideration of ₹9,75,000. This is the agreement. Now, the purchaser will purchase the said land more fully described for a valuable consideration of ₹9,75,000 only of the lands more fully described. Then, the vendor will execute and register the sale deed or deeds in favor of the purchaser of his nominee or nominees within 25 days from the date of agreement at his own cost and expenses of the purchaser before such as. If the vendor fails to get the said sale deed, execute and register within the stipulated period, the purchaser shall be at liberty to make the vendor bound to get the sale deed executed within the period with the help of proper court. the vendor shall not encumber the said lands in any way, such and such. Now, if I put a question to myself, who are parties to this agreement? What is to be specifically enforced, and who would have been the best person to get it executed through courts of law?
Defendant number 3.
He is
Defendant
not a
number 3
plaintiff.
is not a plaintiff.
Yes, now your lordship may kindly see why I was harping that why the issue has not been framed in respect of this agreement 1/4/2008. Therefore, the question of law which has been framed by your lordship, it could have been returned. Findings could have been returned in respect of this, that this agreement is forged, this agreement is wrong, illegal contract. But nothing has been touched. Now, one thing more, your lordship may kindly see, in respect of the previous agreement, each and every part of the land has been sold by the defendant number 1 and 2 initially for 23 decimal, and there is no dispute. It is the case of the plaintiff that the rest amount has been sold by 4 sale deeds and covering the rest amount, rest area. So, what is to be executed? Whether in existence of these 4 sale deeds, a defendant number 1 can be forced to sell the remaining part of the land, if at all there would have been. And that is the decree. Now, your lordship may kindly put.
Moreover, in this particular portion, there is another aspect that there is a consideration of amount of rupees 9 lakh.
9 lakh 7, maybe galat ho se sahi ho.
गलत
ये
है
तो-
सही एग्रीमेंट तो है ही।
Yes. Now, this is not a simpliciter suit for declaration of decree. It is your lordship has to confine, and the plaintiff has to confine this suit within the 4 corners of the specific relief act, and which prescribes a mandatory provision, section 16(1)(c). And there was an issue by the trial court. Number 1, first basic inherent defect in this suit. The defendant number 3 is not the plaintiff, who got an agreement subsequently on 1/4/2008. He wants execution. Who wants? Plaintiff. Plaintiff wants execution of an agreement 1/4/2008 between 2 persons who are the appellant and the defendant number 3. Number 1. Number 2. If at all the agreement is to be considered valid, how it could have been valid? I am submitting against me also that a person who already sold the 23 decimal jointly with Chandan Chakraborty. Now Chandan Chakraborty has sold, admittedly they also admit this is their case. I will not add a single word. This is the plaintiff itself that 1/4/2008 4 sale deeds have been executed by Chandan Chakraborty for the entire remaining area, and he received the balance amount 4,29,000. Now, my next question, whether the deed of disclaimer, an unregistered document, can prevail over the agreement. This is the next. Now, the your lordship kindly see for a moment the findings and the learned both the courts returned the finding. Your lordship just see for a moment the trial court judgment first. Is para number 6. Para 6 मुझे पढ़ा जाए. Para 6. Para 6.
of trial court judgment.
Para 6.
That is paragraph number 6. On
6
the other
मुझे पढ़ा
hand,
जाए. Para 6.
on the other hand,
नहीं para 6 मुझे
Issue frame.
issue है. Sorry. Sorry.
issue
Para
frame or para 6 में
Para
दो-
6
दो
model
लिखी
issue है. Yes. Now there are 6 issues. Your lordship just see valid cause of action, maintainable, barred by law of limitation. Whether there is a concluded contract between the parties dated 27/4/26, 2006 with respect to Schedule A property. Whether the plaintiffs are ready to perform their part of contract as per agreement to sale dated 27/4/2006. Whether the plaintiffs are entitled for a decree of performance of contract 27/6/2006. There is no issue with regard to 1/4/2008. I am not wrong in submission in the admission stage itself. Now, your lordship may kindly see what are the findings returned. The nature of documents explained in para 7. Again, I am not repeating.
Yes, I don't repeat that. Let us see straight away the finding.
Now, your lordship just come to
General page 12.
yes, para page 55. Page 55, we are running page 55. Next page. Yes. Yes, last paragraph. Although the entire episode of receiving the balance consideration amount by the defendant number 1 and executing sale deed for the remaining land of Schedule A was as well within the knowledge of the defendant number 1, but he started making trouble, which resulted in criminal litigation between the plaintiffs and the defendant number 1, which culminated such and such, such and such. Oh, line line. Consideration amount of rupees 4,29,000 was duly received by the defendant number 2 on behalf of both the vendors, and also admitted that owing to some problems he could not join in the execution of the sale deeds. The defendant number 1 by a separate agreement, now this is for sale dated 1/4/2008, also agreed to sell his share 38.5 decimal of land in favor of the plaintiff's nominee Jonathan. Now the word is nominee. Now your lordship does not find this word in the agreement itself. Whether my submission is that what is not in the document can be construed by the learned trial court as a third case could be made out. Next, this wrongly proceeded both the courts in this manner. I will again refer to
आगे पढ़िए ना.
आगे पढ़ देता हूँ. The defendant number 1, so it is has not disputed at the receiving of rupees 15,21,000 out of the total consideration jointly with the defendant number 2.
These are the facts. आगे पढ़िए. After hearing the law.
After hearing learned counsel for the parties as well as on consideration of the pleadings and the oral and documentary evidence adduced by the parties, it transpires the defendant number 1 has not, that is also error of record. I will refer para 15 to 18 of the WS.
You see, WS से नहीं होगा ना, oral and documentary evidence से.
हाँ तो pleading के ऊपर है ना documentary आएगा.
Pleading तो रहेगा ही. Pleading तो रहेगा, everything denied.
Pleading के बाहर अगर evidence होगा तो it is inadmissible.
ऐसा नहीं. The
Has
defendant
not disputed the execution of agreement that is इतना and disclaimer dated 31/3/2008 and the agreement for sale dated 1/4/2008. However, in para 17 of examination in chief, he has taken a name excuse that having regard to his old and ailing father, he had to agree with the condition mentioned in the 30th Panchnama, deed of disclaimer, as well as agreement for sale dated 1/4/2008. But no such case has been pleaded in the written statement. Apparently, it is an afterthought. Again, in para 40, he has stated the Panchnama and the deed of disclaimer were got executed by him on false promise that the plaintiff should compromise the criminal case. That is the part of the disclaimer. I will just show. In para 7 of the cross-examination, examination chief, the plaintiff paid rupees 3 lakh to the defendants, but he has stated the same was the sale price of bricks lying on the suit land. But there is no such pleading in his written statement. It appears that rupees 3 lakhs was paid by the plaintiff to the defendant on 27/6/2006, the receipt of which acknowledged by the defendants on the last page, Exhibit 1, sale agreement. In para 29, defendant number 1, PW3 has admitted that after the plaintiff filed present case in court, he came to know that defendant number 2 had received rupees 4,29,000 from the plaintiff number 1. He had executed 4 sale deeds threatening transferring the remaining land of Schedule A, but this statement appears to be false in view of the deed of disclaimer dated 1/4/2008 executed by him, which much before that 7 days before the filing of the suit, and it shows that he has not come before the court with clean hands. The evidence of PW1, plaintiff 1 remained intact in his cross-examination such and such. Now, if I pose a question for myself, that whether the plaintiff shall succeed on his own leg or on the weakness of the defendant. Next. Now, coming to the documentary evidence, the defendant number 1 has not disputed the execution of the agreement dated 27/4/6, deed of disclaimer dated 31/3/8 or Panchnama 30/3/8, agreement for sale 1/4 as noticed. Exhibit 1 and 2 show that both the defendants 1 and 2 received rupees 15,21,000 from the plaintiffs out of total consideration 19,50,000. The deed of disclaimer dated shows in para 1 of the page 2, defendant number 1 has acknowledged that he along with defendant number 2 received rupees 15,21,000 and out of rupees 19,50,000 and the rest amount 4,29,000 has duly been received and acknowledged by the partner Chandan Chakraborty on 4/10/7. He has also admitted that he had received 7,60,500 out of the share 9,75,000. Out of the consideration amount 19,50,000 and the rest 2,45,000 was lying with the friend Chandan Chakraborty, which will be paid to him by Chandan Chakraborty at the time of execution of registered sale deed in favor of Janardhan Prasad. He has also declared that the sale deed executed by Chandan shall be deemed to be executed by himself as well as Chandan Chakraborty. He has no objection on the sale deed such and such. Thus, from the above, it is crystal clear that a valid sale agreement was entered into between the parties, the plaintiffs and the defendant number 1 and 2 on 27/4/2006 and full consideration amount of rupees 15,21,000 was received by both defendant number 1 and 2 and the remaining rupees 4,29,000 was received by defendant number 2, which was duly acknowledged in the exhibit 3. Having agreed to receive the share of money, he promised to execute the sale deed and permitted to take a U-turn is stopped from doing so in view of section 115. Thus, from the above it is crystal clear the plaintiffs were ready and willing. Now where is the discussion? Where is the document on record? Ready and willing to perform their part of contract. In fact, they have already performed their part of contract. Defendant number 1 has not been willing and ready to perform his part of contract. Now, this is important. Now a question may arise as to when the sale deeds with regard to the land of the share of the defendant number 1 has already been executed by the defendant number 2 and the same is still in existence. How the defendant number 1 may be directed to execute a fresh sale deed in favor of the plaintiffs or their nominee, that is defendant number 3, with regard to the same land, unless those sale deeds are cancelled, and that too when no relief for the cancellation of those sale deeds has been sought for. This is the question arose in the mind of the learned court. Now reply. In my opinion, without any basis and without any finding, in my opinion, even in absence of any relief sought for by the cancellation of sale deed, Exhibit 5 series, the order for cancellation of those sale deeds can very well be passed by this court by way of equitable relief as prayed for by the plaintiff. So this is the observation. Where is the finding? The sale deeds are cancelled. So the court thought it proper that yes, the sale deeds are already on record, Exhibit 5 series, and in absence of cancellation of those Exhibit 5 series, how the defendant number 1 can be asked to execute a sale deed again for the same property? Now the no answer to this question by the learned trial court has been recorded, nor the sale deeds were cancelled. On the other hand, now issue number 4, issue number 1 and 2, issue number 3 with regard to 16(1), your Lordship just see, in view of the findings of this court on issue number 5 and 6, it must be held there is a concluded contract between the parties with respect to such and such, and this issue is also decided. As per the issue of limitation, it is within 3 years decided.
What is the direction?
Now, the suit.
Who has to execute the sale?
Page number
Who
6.
has to execute the sale?
Yes, yes. The suit be and the same is hereby decreed on contest and the parties will bear their cost. All the 4 sale deeds executed by the defendant number 2 bearing such and such in favor of such and such, 5 series जो है जो executed in favor of Sasi Verma and Ravi Verma contained in exhibit 5 series respectively are hereby. Remaining area of itna is in favor of plaintiff.
Are hereby क्या?
Are hereby. उसके बाद जो
नहीं, last line missing है.
कहाँ
ये वाला ये
हाँ
कमी
ठीक my learned friends का are hereby cancelled and the defend number 1 the pro forma defend number 2 are directed to
कहाँ है
jointly
hereby
execute
cancelled?
है जो last में
Order.
Are hereby cancelled and the defendant number
number
1
1 and 2 now
One, and just a moment, pro
Yeah.
forma defendant number 2 are directed to jointly execute the fresh
Sale
sale
deeds
deeds
with regard to remaining area of such and such. Now the question arises. The learned trial court already framed a question himself. Whether in a specific performance of contract suit, it is not a general suit, it is not a relief sought for, admittedly. Therefore, I referred not the relief. Then I got it not the question of the frame for by LOC. Now it is 1/4/2008.
You see, the agreement of sale is of the year 2006. Subsequent documents are only arrangements.
Yes.
Vis-a-vis agreement of sale.
Now the language which I have read from 1/4/2008. The parties who are there.
Yes.
Number 1. Number 2. Reliefs I have already quoted.
The Honorable Supreme Court says that if there is any
No, it is not in during dependency.
that's right.
It is prior to suit. It is prior to suit. So this
therefore-
relief was available to them at the time of drafting plaint. No such relief has been asked for. Now a valid agreement can be executed through court. Now when there is no agreement itself between the plaintiff and the defendant number 1, how it could have been executed, how the court can grant a relief to the plaintiffs to get it executed through defendant number 1 in respect of the property which they have already acquired by Exhibit 5 series. Now what is the reply of the learned appellate court? Your Lordship, just see for a moment. Paragraph 4, 10 and 16. Appellate court judgment.
The court cancels the 5/4
Yes.
sale
What?
deeds.
In absence of any relief. And that is also in a suit for a specific performance of contract. In absence of any relief. Court cannot go beyond the pleadings. Court cannot travel beyond the relief sought for. So what has not been prayed, the court makes out a third case and allowed the third case. Forgot about the case originally claimed by the plaintiff.
And hereby and defendant number 1 and pro forma defendant
Yes.
number 2
Now
are
where is the
directed
prayer?
to- No.
रिलीफ में हुजूर एक बार देखा जाए फिर कहाँ बोला कि डिफेंड नंबर 2 कॉन्जॉइंटली एग्जीक्यूट करेंगे रजिस्टर्ड सेल डीड इन एब्सेंस ऑफ एनी रिलीफ नाउ योर लॉर्डशिप में काइंडली सी द appellate court judgment paragraph 4 10 and then 16 these three paragraphs I will be permitted to refer to
क्या करता है देखो इन सब चीजों को appellate कोर्ट ने क्या किया डिसमिस किया
नहीं डिसमिस की
What are the points for determination?
12 सेकंड
हुजूर पैराग्राफ 4 पहले हम 1 मिनट के लिए पढ़ा देंगे उसके बाद
पैराग्राफ 14 पॉइंट्स को
यहाँ हम आते हैं मूवी पर पैराग्राफ 16 इज द अल्टीमेट फाइंडिंग पैराग्राफ 4 का हुजूर देखा जाए ये जो डिफेंड नंबर 1 का जो केस है हम बहुत ज़्यादा नहीं बोलेंगे एक ही चीज़ बोलेंगे जहाँ से हम क्या क्या प्ली लिए थे अब कहते हैं हम प्ली नहीं लिए हैं पैराग्राफ पेज 15 पेज 13 का हुजूर टुवर्ड्स मिडिल statements made para 8 to 11 are not true. Defendant stated he was never shown any unwillingness to comply the terms of agreement, rather the plaintiff or the nominee was never agreed to pay the marketable price. वो सब लंच बन रहा है, सब नेट। जो अब देखा जाए, defendant number 2 was not lastly allotted or demarcated the lands of the defendant number 1, and there was no intensity arrangement. Therefore, the defendant number 2 has got no locus standi to sell the property as alleged by 4 sell deeds. ये सब हो गया अभी और पेज 15 में हो दिए हैं towards middle panchayat number. The defendant states that the so-called panchayati as alleged by the plaintiff is meaningless as the matter of fact no panchayati decision can supersede or enforce any terms of valid sale agreement. Moreover, the answering defendant has not been offered his legitimate dues out of the agreement. Not only that, the agreement can only be invoked and enforced on the plot in question followed by particular area. The defendant further states that the plaintiff is not entitled to any area in accordance with the boundary, but whatsoever the land exists which does not form part of the plot number agreement, but the plaintiff very cleverly trying to include the purported agreement is not legal and valid. The defendant is not in a position to deny the statement of such an. Then your lordship may kindly come to page 16. Finding starts from para 13. Para 13 से जो finding start किए हैं.
Point for determination.
अब point for determination ये para 14. Para 14. Page 24. Whether there is concluded contract between the parties on 27/4/2006 with respect to Schedule A property, whether the plaintiffs are ready to perform their part of contract as per the agreement to sell, it is 27/4/2006, whether the plaintiffs are entitled for a degree of specific performance of contract on 27/6 for any other relief or relief. 3 issue है, बाकी छोड़ दिए. Point number 2 and 3 are taken up together. अब जो पेज नंबर 16 में आ जाए, पेज नंबर पैरा 16 पेज नंबर 28.
Yes.
28 में डायरेक्ट आएगा. पेज नंबर 28 का जो फर्स्ट पैराग्राफ का कंक्लूडिंग है, दिस सूट इज फाइल्ड ऑन ready to execute. The defendant number 1 was reluctant to execute the sale deed in favor of the plaintiff. The suit is filed on 29/4/2008. The defendant number 1 agreed to transfer the land within 25 days in deed of agreement dated XRR, Exhibit 1/A. So this was taken into consideration, Exhibit 1/1, and within 25 days, suit was brought by plaintiff. Agreement for defendant number 3. Now your lordship may kindly see the next page. Next page. On the basis of the aforesaid facts and discussion, the court direct the defendant number 1. Court has to direct.
No, you see, agreement is 1/4, 25 days का हुआ, 26 को.
26 दिन, 26/4 को होगा. कि केस 29 को हुआ, लेकिन वो तो नहीं लाया.
ठीक.
डिफेंड नंबर 3 नहीं लाया. जो भी हो, plaintiff agreed to transfer to हुआ. On the basis of the aforesaid facts and discussion. Now, what are the discussion? That is page 28 का जो second paragraph. The court has to direct the defendant number 1 to execute the sale deeds in favor of the plaintiff to conclude his part performance of contract. The learned court below has rightly held the sale deeds with regard to share of land of defendant number 1 executed by defendant number 2.
Where are you reading? Internal page 28.
28 का जो लास्ट पोर्शन को हम छोड़ दिए.
हाँ.
उनका फाइंड अल्टीमेट ऑब्जर्वेशन 29 का जो पढ़ रहे हैं टॉप.
हाँ. On the basis of that
वही on the basis of the aforesaid facts and discussion, the court has to direct the defendant number 1 to execute sale deeds in favor of the plaintiff to conclude his part performance of contract. The learned court below has rightly held that the sale deeds with regard to share of land of defendant number 1 executed by defendant number 2 is still in existence, and those sale deeds must be cancelled by way of equitable relief to the execute a fresh deed in favor of the plaintiffs or their nominees. The contesting defendant number 1 has also taken a plea in para 17 that as a matter of fact, whenever defendant number 2 executed the alleged 4 sale deeds, 77 dismissed, no land is left for defendant number 1 to execute in this respect, either these should be cancelled, then the question of execution or registration arises. More so, if the learned court will pass any order or decree, that decree will almost tantamount to unexecutable. Thus, the question of execution and registration of the deed by defendant number 1 does not and cannot arise. Thus, the learned court below rightly adjudicated issue number 5 and 6 in this suit has given finding finally in favor of the plaintiffs, which require not to be interfered, and as such, point number 2 and 3 are decided in favor of the. Where is the discussion of own finding? His own finding and reaching to the conclusion. He affirmed the findings recorded by the learned trial court, and that is also without any discussion. Concurring, maybe, but there must be question of fact is to be finally decided by the appellate court. Other points were not left open, not decided, since the main issue has been decided.
क्या बोलना है आपको?
Yes, Lordship, we can see para 4.
Para 4.
Order, the first order order, Lordship. When this case was admitted by this honorable court, Lordship.
वो एडमिशन में जो हम अपना ऑब्जर्वेशन दिया उसका क्या
नहीं,
relevance?
ऑब्जर्वेशन नहीं, जो सब्सटेंशियल क्वेश्चन ऑफ लॉ फ्रेम हुआ है वो हम दिखाना चाह रहे हैं.
बताइए.
Considering the submission, this appeal is admitted for hearing on the following substantial question of law: whether the learned courts could have decreed the suit without framing any issue in connection with agreement dated 1/4/2008, Lordship. Now, Lordship, this objection was never raised by the learned before the learned trial court nor the appellate
May
court,
not
Lordship.
have. But your entire case was based on this agreement. And
Lordship,
there are findings recorded in connection
but
with
Lordship,
it.
this honorable court only see the substantial question of law framed by this honorable court.
Yes, yes, I
May
will-
kindly see order 14 rule 5, Lordship, of the CPC, Lordship. Order 14 rule 5. Order 14 rule 5. May I read, Lordship? Power to amend and strike out the issues. The court may at any time before passing a decree amend the issue or frame additional issue on such terms as it think fit. In all such amendments or additional issue as may be necessary for determining the matter in controversy between the party shall be made or framed. The court may also any time before passing a decree strike out any issue appear to be wrongly framed or introduced, Lordship. But the Lordship, the defendant did not file any application for framing of second agreement, Lordship. And neither raised before the learned trial court nor raised before the appellate court. He is making submission first time before this honorable court, which is not permissible by law, Lordship. And now, Lordship, may kindly see deed of disclaimer, Lordship, Exhibit 3. Once again, Lordship.
No, let's pause here for a moment.
Lordship.
So, your first argument is that this point is not available because he has not raised his plea at any stage.
Lordship. Lordship, may kindly see deed of disclaimer, Lordship. Exhibit 3, Lordship.
You see, you are only, then you should only confine to the agreement of 2006.
Yes, he also confining, Lordship, may kindly see deed of disclaimer, Lordship. I mean, we permitted to read, Lordship, entire, Lordship. He did not read the entire, Lordship.
Deed of disclaimer, you see, the property, it is relating to property. Can any deed of disclaimer be filed in connection with the name of property?
Lordship, may kindly see para 39 of the cross-examination of the defendant number 1, Lordship. He admitted that the deed of disclaimer is a valid document, Lordship. He admitted before the honorable court, Lordship. If anything admitted before the honorable court, and admission is the best piece of evidence, Lordship. He admitted, mechanically 39 of the
Let us take it that he admitted. So what is the consequence?
Lordship, he also admitted that.
You see, by virtue of subsequent agreements, the original agreement got substantially modified.
Not modified, Lordship.
Yes.
Lordship, may I see deed of
That is your
deed of
relief
dis-
also. That
Lordship,
is your relief
Lordship,
also.
may I see deed of disclaimer, Lordship. He admitted the first agreement also.
Yes,
I
it is
mean,
an admission. That first agreement is there.
there.
Yes, then
And second, Lordship, that is the alternative arrangement, Lordship.
what alternative agreement?
That is the alternative arrangement, Lordship.
How the subsequent sale deeds could be cancelled?
Lordship, cancel was subsequent sale deed was only cancelled because it was unilaterally executed by the defendant number 2, Lordship.
Why? There was no relief.
No legal sanctity,
No,
Lordship.
but there is no relief.
But the court has power, Lordship.
What power?
Lordship, sale deed was executed by the defendant number 2 in favor of the some persons, Lordship. Unilaterally, the learned trial court has rightly cancelled the.
Why? Without any prayer. The sale deed will be cancelled. The sale deed will be cancelled without any prayer. You see, you were essentially seeking the execution of the agreement of the year 2008.
No.
Yes.
Lordship, make and see relief portion, Lordship. Page para 26, Lordship. The plaintiff therefore pray for following relief: a decree for a specific performance of agreement for sale dated 27/4/2006, in so far as defendant one is one untransferred sale of 38.5 decimal of land of Schedule A is concerned, directing the defendant number 1 to transfer 38.8 decimal of untransferred land, being the residue share of the defendant number 1 in Schedule A in favor of the plaintiff or their nominees. Janada Prasad in terms of agreement dated 27/4/2000, read with the agreement dated 1/4/2008. Or in case the learned court is of opinion that the agreement dated 1/4/2008 is not sublimate to part of the extinction of the agreement dated 24/8/2000, rather the separate the degree for a specific purpose the agreement dated may kindly be passed in favor of Janada Prasad. The Janada Prasad is a nominee or representative of the plaintiff, Lordship. Therefore, he was made the performer defendant number 3.
But the agreement of 2008 is between Janardhan Prasad and
Appellant.
and defendant number 1 and defendant number 3.
Yes.
Janardhan Prasad never came up before this court.
Neither
He is
came,
not the plaintiff.
did not plaintiff, but he is the performer defendant.
So,
He can support the case of the plaintiff, Lordship.
yes. So,
He is the performer defendant, Lordship. Meaning thereby he is the also plaintiff, Lordship. He is also plaintiff, Lordship. He is the performer defendant, Lordship. The sale deed is also executed in favor of the Janardhan, Lordship. My submission is that make an issue para 14 and 15 of the written statement, Lordship. That the statement made in para 14, that the statements made in para 17 to 19 of the plaint are wholly false, baseless and misleading. The defendant stated that defendant number 2, whatever received payment from the plaintiff for which the defendant is not all binding and responsible in as much as the defendant never give any permission for making payment of defendant number 2. The defendant number 1 stated that he was never disagreed to comply the terms of agreement, rather transfer of land in question in relation to particular plot comprising particular area, but there is no such any supplementary agreement of second agreement wrongly alleged in plaint. He also not believing the second agreement, Lordship. No. आप
अरे भाई एविडेंस में तो आ ही गया ना कि एग्रीमेंट हुआ था कि नहीं हुआ
एग्रीमेंट तो हम लिखे हैं कि हुआ ही है।
हुआ था ना, तो उनकी बात छोड़ दीजिए, वो क्या मान कर रहा, आप तो मान रहे हैं ना कि एग्रीमेंट हुआ था।
हम तो मान रहे हैं कि एग्रीमेंट हुआ, only for temporary arrangement, Lordship.
What temporary?
That is para 15, that it is very relevant to state the plaintiff as para 70 of the plaintiff stated the plaintiff paid total consideration amount of 90,500 to Chandan Chakravarti for on behalf of both the vendors. In this case, also the entire consideration amount have already been paid.
Has already been paid to whom?
Paid to his partner.
What partner?
15 lakh something
तो
पे
पार्टनरशिप डीड है इनका।
पार्टनरशिप नहीं है,
पार्टनर कैसे होगा?
एग्रीमेंट होल्डर तो है ना,
एग्रीमेंट होल्डर होने से भी क्या?
एग्रीमेंट होल्डर है।
ठीक है, आप आप एग्रीमेंट करिएगा चार आदमी के साथ, है ना, और सारा कंसिडरेशन अमाउंट एक आदमी को दे
नहीं,
देंगे।
खुद एडमिट कर रहे हैं कि डीड ऑफ डिस्क्लेमर है कि 2 लाख समथिंग इज पेंडिंग बिफोर द डिपेंडेंट नंबर 1. Lordship, may kindly see deed of disclaimer, Lordship. I may be permitted to read the entire deed of disclaimer.
भाई तो इनको पैसा कैसे मिलेगा?
इनका after execution of the sale deed, he admitted.
भाई, now the sale deed is cancelled, right? The entire consideration amount has already been paid. The court only asks for execution of a fresh sale deed,
Fresh sale
right?
deed.
Or consideration.
Consider 2 lakh something
Who will pay to whom?
by the defendant number 1.
Who will pay to whom?
Defendant number 1 to defendant number 2. Sorry, defendant number 2 to defendant number 1, Lordship.
और कहाँ है
हाँ
डायरेक्शन?
देखिए,
कहाँ है डायरेक्शन?
नहीं डायरेक्शन नहीं, मगर एडमिट कर रहे हैं डीड ऑफ डिस्क्लेमर में.
कैसे होगा? वो पैसा डिपेंडेंट नंबर 2 के पास कैसे आएगा?
आएगा आफ्टर रजिस्ट्रेशन ऑफ द सेल
कैसे आएगा?
लिखा हुआ
You see,
एडमिट
the
कर रहे हैं.
entire consideration amount has already been paid, right?
Lordship, I may be permitted to read the deed of disclaimer entire, Lordship. It is
आप हमको डीड ऑफ डिस्क्लेमर से मैच कराइए रिलीफ को।
नहीं deed
आपको क्या रिलीफ दिया है?
to execute the sale deed, Lordship.
हाँ, और कोई कंसिडरेशन तो आपको देना नहीं है
नहीं
amount।
कोई कंसिडरेशन
इन
नहीं
लोगों का
है.
आपस का क्या होगा?
अरे लोग ये खुद एडमिट कर रहे हैं कि जब सेल डीड होगा तो इनको हम पेमेंट कर देंगे.
कौन पेमेंट करेगा?
डिफेंडेंट नंबर 2 to defendant number 1.
तो डिफेंडेंट नंबर 2 टू डिफेंडेंट नंबर 1 का आपस में कौन सा रिलीफ है इसमें?
नहीं इसमें रिलीफ तो नहीं है.
तो फिर
रिलीफ तो नहीं है, हमारे एडमिट कर रहे हैं ना खुद डीड ऑफ डिस्क्लेमर में. हम एक बार पढ़ देते हैं, हमको पढ़ने दिया जाएगा.
पढ़ी
ठीक. Whereas I along with Chandan Chakrabarti has purchased above mentioned property in auction at the sale by public auction on so and so date arising out of execution certificate number itna for debt recovery tribunal Ranchi. Whereas I Chandan Chakrabarti has jointly received 15,21,000 rupees and out of the highest consideration amount of 19,50,000 rupees from purchaser which is duly due and acknowledged by us. Rest due of 4,29,000 has been duly received acknowledged by my partner Chandan Chakrabarti on 4/10/2007. Where owing to some legal and personal problem, I could not come to the registry for execution of the registered sale deed in favor of Janardhan Prasad and Srimati Indu Devi. Hence, the sale deed in favor of these persons were executed by Chandan Chakrabarti. Only the sale deed number so and so. Although I have received 7,60,505,000 out of my share, 9,75,000 of the entire highest consideration amount, that is 90,50,000, and 2,45,000 lying with my partner Chandan Chakrabarti. खुद बोल रहे हैं 2 लाख जो है 2,45,000 चंदन चक्रवर्ती के पास है. Will be paid by the Chandan Chakrabarti at the time of execution of registration of the sale deed in favor of the Janardhan Prasad or sub registry office Dhanbad, whereas it was my legal obligation to maintain the sanctity of the sale agreement dated 27/4/2006 by and between the Chandan Chakrabarti, Hridayan and Bharti, but owing to some problem I could not maintain the same. Now I hereby agree to execute a registered document in favor of Janardhan Prasad to purchaser to avoid any type of litigation which may raise in future regarding property mentioned in para 1 of this document. Further, I declare that sale deed executed by the Chandan Chakrabarti shall be deemed to be executed by both, that is Chandan Chakrabarti, Hridayan and Bharti. I have got no objection on sale deed of Janardhan Prasad Hindu they be executed on 10 so and so. I further declare I will never raise any claim regarding the property mentioned in para 1 and further declare undertake that neither nor any successor representative here assignee will interfere with the title and possession of the purchaser. Furthermore, I and all my heirs, successor, representative, administrator shall at all times hereafter indemnity and keep the purchaser indemnity against the law, damage, cost, charge and expenses if any suffered by reason to my defect in the title and possession or any dispute if raised from my part. That I further declare that I will hand over the vacant possession of the property mentioned in para 1 to its purchaser within 12 hours from that time signed by me on this document. That I further declare undertake that I will sign the document whenever the purchaser requires. So far as confirmation of the above property, I will deny do so. I will be liable to pay entire damages to the purchaser at the rate of 50% of total consideration. constitution of my share lordship. ये एडमिट कर रहे हैं जिसमें सेल डीड करने जाएंगे उसमें उनको 2,45,000 रुपया डिपेंडेंट नंबर 1 पे करेंगे. दिस इज माय सबमिशन. अब 1239 करोड़ से एग्जामिनेशन में एडमिट भी कर रहे हैं डीड ऑफ डिस्क्लेमर के बारे में.
एक छोटा सा जवाब है सिर्फ 1 मिनट. जो डिस्क्लेमर का पढ़ रहे हैं तो इट इज बेस्ड अपॉन पंचायत जो भी हो. नाउ ए क्वेश्चन अराइजेज whether a right of relinquishment, it is the nature of relinquishment, can be considered on the basis of an unregistered document under section 17 subsection 1 capital A of the Indian registration. It amounts to transfer his right and right to relinquish his right. So a property more than value of rupees 100 is being his right, legal right is being transferred or relinquished by virtue of Exhibit 3, and whether that document can be constituted. And that in this plea has not been taken for the first time. It has been taken, my learned friend has taken pain to read para 14 and 15 of the written statement, abandoning the para 17 and 18 thereof. And Panchanama says that they have lodged a criminal case, they will immediately withdraw this case before 1/4/2008, and which has not been done. Now they are harping about the admission on the part of the plaintiff, on the part of the defendant. But the 3 documents, Panchanama first, then disclaimer, and then agreement 1/4/2008. Number 1. Number 2, Chandan Chakraborty appeared before the court and said, I have not been paid the amount. And he is also appearing in this case also. My learned friend is appearing on his behalf. There is no direction upon Chandan Chakraborty to pay this amount. So the relinquishment cannot be constituted as a legal document in view of the non-registration of that document.
और ये issues के बारे में क्या बोलना है?
हमको-
That you never raise any
Yes, yes.
objection.
Now this is a question, Lord. I would not, because after the judgment it found it was detected, and we have that this 1/4/2008.
After the judgment in the issues
Yes, yes.
तो आपको सुन के बना होगा.
Yes, सूट में नहीं, सूट 1/4/2008 के बारे में जो मेरा इतना ही सबमिशन है. If Lordship may kindly see when the issues can be cast even at the time of writing judgment. When the learned courts felt it proper that 1/4/2008 agreement is the basis of the claim of the plaintiff, then at the very initial stage that could have been framed, that has not been framed, and they have left this issue, and but decided, findings recorded. Now,
This is order 14 once again.
Order 14 Rule 5 Lords.
This is for the court. Court may at any time before passing a decree amend the issues.
भाई
और-
issue amend करके तो evidence होगा ना.
हाँ तो होगा, तो amend और delete और frame additional issue. ये केस नहीं ना है यहाँ.
नहीं ये तो कैसी है
इशू नहीं फ्रेम किए, तो कहाँ फ्रेम
मैं
किए?
एप्लीकेशन आते से
कौन हम एप्लीकेशन दे चाहे कोर्ट में at any time. So that is the power of the court. It is not for the parties. That is the reason of what I submitted. Had it been for parties, then you will see may kindly see paragraph issue order 14 rule 1 का sub rule 3. Each material proposition affirmed by one party and denied by other the issues, the form the subject of a distinct issue. Issue are of two kinds, issue of fact and issue of law. So it is for the due to divergent pleading of the parties, the issues are required to be framed and then the findings can be returned. But findings returned, no issue.
But he never raised.
It is not necessary. Order 14 Rule 5.
Framing additional issue.
Order
also.
14 Rule 5 does not say the party has a power. Party has the liberty. It is for the court, not for the party. Like Lordship may kindly see parallel argument. Even in Order 26 Rule 9, there are two clauses A and B. One for the court, another for the party for pleader commissioner. Likewise, here there is no scope for the party to file an application for addition. That is for the plaintiff.
But he can raise before the learned appellate court also.
Here I am raising.
No, it is not the appellate
Here for the appellate court.
No, it is the second
It is
appeal.
the continuation of a civil
He
case.
never raised before the learned appellate court. Lordship.
The law is very clear. The second appeal is continuation of
If
a
it is raised, Lordship, the appellate court can return
Let it show any judgment
frame
that
the issue and return to the learned trial court.
My
For
learned
framing
friend
issue,
any
Lordship.
judgment that they divorce the issue a law point.
You see, in a circumstances where issue in connection, the entire relief was prayed concerning two agreements, agreement of 2006 and agreement of 2007. It was very much there in the relief. It was on the face of it. That what is the consequence of this particular agreement, right? And the court has not framed any issue admittedly. There has been certainly an error on the part of the court in not framing any issue with that regard. Now, whether the appellant can be non-suited on this, and whether the court, without framing any issue with regard to exhibit this particular agreement of exhibit 1 by A, can decree the suit in the manner they had done it. They have cancelled the earlier sale deeds, right? They have cancelled the earlier sale deeds and asked them to execute fresh deed on the basis of the agreement of the year 2006, which actually stood modified by virtue of agreement of the year 2008. There was a modification. It is, you see, the court could have various kind of documents can be executed. The court can ask the party to execute a sale deed indicating that this is how it is, indicating that sale deed has already been executed. Now, so far as my portion is concerned, I have already received the consideration amount, or I am about to receive the consideration amount. For my portion, I am executing one more sale deed. Because whatever the sale deed which was previously executed was executed for my portion also.
Yes.
That was incorrect. So, in order to rectify this, I am just executing sale deed so far as my portion is concerned. But this kind of an order, how can you sustain this kind of?
Another aspect, Lord. This is for 78 dismissal. Chandan Chakravarti ka original artist.
Now you see, the point is that this issue has not been framed. And I am quite satisfied that this issue ought to have been framed by the court. The court also has ample duty to frame appropriate issues between the parties. Having not done so, what is the remedy? What kind of decision can be given by this court at the second appellate stage? This is what I am asking.
But Lordship, this is.
You see, I will hold this as I see it now. I am of the view that this substantial question of law, whatever has been framed, has to be decided in favor of the appellant. I am just asking you, what is the consequence? Whether simply both the judgments are to be set aside on this score, or we have to remand the matter for asking them to frame proper issues and then take evidence and come to it. You tell us, you assist us. So this is not acceptable at all. This is not the kind of judgment which is expected from a court. There is no prayer to cancel the sale deed. How the court will suo moto cancel the sale deed? I just absolutely clueless.
Against defendant number 2.
How is it possible?
To the extent
You just
of
see
his
who
share.
are the plaintiffs. Their sale deed has been cancelled. Are you not aggrieved? Are you not agreed by this fact that your sale deed has been cancelled?
But there is also direction to execute the fresh deed
So,
by
what
the
fresh deed?
defendant number
What
1
fresh deed?
and defendant number
Suppose-
2.
Suppose, think of
priority
another situation. Suppose in the meantime, you have encumbered, so far as your sale deed is concerned, आप कहीं mortgage कर देंगे तो उसका क्या होगा? Third party right भी तो create हो सकता है.
That is another thing, Lord.
No,
It is the presumption, Lord.
whenever it is not a question of presumption. It is quite possible. It is quite possible your sale deed has been cancelled after such a long time. Sale without asking, your sale deed has been cancelled. You being the buyer in the sale deed, your sale deed has been cancelled.
कम से कम आधा तो कर सकते थे valid,
What kind of?
जो चंदन चक्रवर्ती किए हैं, कि पूरा को कैंसिल किया.
पूरा को कैंसिल कर दिया और आपको कोई ग्रीवेंस नहीं. You're happy with that.
Why I am happy, Lord, say, because they were the direction of the learned trial court to execute the fresh sale deed, Lord. Say.
और डिफेंड नंबर 2 के खिलाफ कोई रिलीफ भी नहीं मांगे हैं, और उसका पूरा कैंसिल करके उनको भी कह रहे हैं कि आप भी एग्जीक्यूट कीजिए, और उनके खिलाफ कोई रिलीफ नहीं है. कुछ भी कर सकते हैं लायक.
ऐसे नहीं कर सकते.
डिफेंड नंबर 2 के खिलाफ कोई रिलीफ है कि ही में भी
देखिए, I'll tell
डायरेक्टली
you one
इशू.
thing.
Lord.
अगर ये इशू फ्रेम करके हम दोबारा भेज भी देते हैं, no useful purpose is going to be served. Because this particular agreement is between defendant number 1 and defendant number 3. तो कैसे क्या होगा? किस तरह का प्लेंट बना? हमको तो समझ ही नहीं आ रहा है. हाँ, what kind of plaint it is? And what kind of relief the court has given? Equitable relief में कुछ भी करेंगे क्या? ऐसा नहीं हो सकता. डिपेंडेंट नंबर 1 का पोर्शन कितना हुआ? 38.8.
76 सॉरी 77 है तो 38.5
38.5.
38
लिखा हुआ है.
हाँ 38.
अनट्रांसफर्ड शेयर 38.5.
38.
यस यस.
Agreement 1/4/2008 is between
ये डिफेंड नंबर 1 and डिफेंड नंबर 3 is not different.
बताइए, अगर इशू फ्रेम करके भेजना हो तो क्या कैसे करना?
यहाँ से तो इशू
यहाँ से तो नहीं डिसाइड
यहाँ से
होगा.
तो नहीं हो पाएगा. तो वो पावर तो सिर्फ अपीलेट कोर्ट को होगा.
तो आप भी देखो.
नहीं तो सेकंड अपील
Second appeal में है ना, if I give a finding that this issue has been wrongly omitted to be framed, then I have to frame the issue and send. Consequence भी तो देखेंगे ना, खाली question of law answer कर देने से थोड़ी होगा. What is the consequence of this? देखिए आपको रिलीफ फिर भी मिल जाएगा. हम सोच रहे हैं इस चीज़ को, क्योंकि the impact of the agreement dated 1/4/2008 read with the agreement dated 24/4/2006. The court has omitted to frame issue with regard to agreement dated 24/4/2006 read with agreement dated 1/4/2008. Issue ये होना चाहिए. But the court has only confined itself by framing the issue with the 24/4/2006.
जी. रजिस्ट्री ऑफिस में हम लोग 15 लाख रुपए जमा भी करवा देंगे रजिस्ट्रेशन के लिए.
15 लाख रुपए क्यों जमा करा? आपको तो सारा पैसा दे चुके हैं.
दे चुके हैं. हमको आज खबर आया है कि हम लोग जमा किए हैं रजिस्ट्रेशन के लिए.
क्यों जमा?
फ्रेश सेल, जितना भी फ्रेश सेल डेटा.
और पैसा जो दे दिया उसका क्या होगा?
पैसा तुम दे ही चुके हैं.
दोबारा पैसा देने
नहीं,
के लिए
उनको नहीं देंगे. रजिस्ट्री ऑफिस हम लोग कोर्ट फी लगता है जो है ना, जितना भी सेल
स्टैम्प के बारे में
स्टैम्प के बारे में बोल रहे हैं. स्टैम्प के बारे में.
स्टैम्प
ड्यूटी के लिए हम लोग जमा कर चुके हैं.
स्टैम्प ड्यूटी के
स्टैम्प ड्यूटी के बारे में करेक्ट. हाँ 15 लाख. हाँ अपना जमीन हम लोग जमा कर चुके हैं.
78 डिसमिल.
हाँ
पूरा प्रॉपर्टी का,
पूरा प्रॉपर्टी का.
मतलब पुराना भी जो
सेल
नहीं, वो 23 डिसमिल छोड़
तो 23 डिसमिल छोड़ के
23 डिसमिल का तो इनको मिल चुका है. उसमें कोई डिस्प्यूट नहीं.
डिस्प्यूट जो कैंसिल हुआ
78 डिसमिल जो बचा है वो 75
लगभग वही आसपास.
76 का क्लेम के 76 होने से आधा 38
15 लाख रुपया स्टैम्प ड्यूटी के लिए हम जमा भी कर चुके हैं रजिस्ट्री ऑफिस में.
मांगे नहीं कि हमारा सेल डीड कैंसिल करके फ्रेश दीजिए. कोर्ट सोचे दे दिए.
see there is one more thing. Let's see this first. Even if no specific issue is framed and the parties during the course of trial join issues on that, that is they join issue on the impact of the agreement dated 1/4/2008, the trial cannot be said to be mistrial merely because of issue has not been framed. If the parties are otherwise joining issue with respect to one or the other aspect of the matter, then also the judgment can be sustained. This is one thing. There are judgments on this. But the point is that if this particular agreement, if the consequence of this agreement is taken into consideration, that is agreement dated 1/4/2008, then under such circumstances the relief which has been granted by the court is absolutely not.
करेक्ट.
The relief जो दिया है वो defective relief.
तो गलत हुआ है.
Would that relief cannot be sustained.
सेल डीड कैंसिल
Cancel का कोई स्कोप ही नहीं था.
ड्यूरिंग पेंडेंसी अगर बेच खरीदते तो, लेकिन इट इज अ केस नॉट प्रायर टू दिस सूट. जो सेल डीड हुआ एग्जिबिट 5 से ऑल आर प्रायर टू दिस सूट. हैड इट बीन अ केस नॉट इन सेक्शन 53 टीपी एक्ट में इट लीज
2006 का तो बाद ही हुआ ना.
हाँ 2006 का बाद सूट जो
2006
सूट फाइल हुआ जिस दिन सेल डीड होने के बाद, सेल डीड जब हो गया जो एग्जिबिट 5 से उसके 28 दिन,
अगर मान लीजिए कोई एग्रीमेंट ऑफ सेल हो जाता है और एग्रीमेंट होने के बाद सेल डीड एग्जीक्यूट हो जाता
पूरा
है,
जमीन का हो गया.
पूरा जमीन का हो जाता है मान लीजिए, और उसके बाद स्पेसिफिक परफॉर्मेंस ऑफ कॉन्ट्रैक्ट फाइल
तो
हो
फिर
जाता
कहाँ रहा, किसके लिए? जमीन के लिए.
है. हाँ, जमीन के लिए.
जमीन कहाँ रहा? अगर इस सेल डीड ले लिया आपने, टाइटल होल्डर बन गए, तो किसके लिए स्पेसिफिक परफॉर्मेंस?
डिफरेंट नंबर 1 जो है
डिफरेंट नंबर 1 आप लिए जान सकते
साइन नहीं की है.
1 और 2 का
दोनों पार्टनर हैं.
वो तो आपका नहीं है. 1 और 2 मिल के इनको एग्रीमेंट किया शुरू में, अब वो 2 पार्ट का बेच दिए, तो ये क्लेम तो नहीं है कि भाई 1 का 38 डिसमिल लेते 2 का,
तो जो ट्रांसफर इनका फेवर में होगा वो भी चला गया।
वो भी चला गया। आप तो सेल डेट को चैलेंज नहीं किए इस जजमेंट को, क्रॉस ऑब्जेक्शन भी नहीं डाले कि ये पार्ट गलत है। इन एब्सेंस ऑफ एनी रिलीफ sought in the second appeal, how this honorable court will extend such relief to him in absence of any cross appeal?
लिखिए भाई। Or the learned counsel appearing on behalf of the parties. आपको जाना है? जाइए।
5 सेकंड से भी
आप जाइए।
फेल हो गया।
इतना आपका कॉम्प्लिकेटेड फैक्ट रहेगा तो क्या ही होगा।
I'm very sorry, हम
कोई बात नहीं।
बोलना नहीं चाह रहे थे, मुझे कुछ बोलना
नहीं आप जाइए, आपको अपना करना है।
very much.
Heard the learned counsel appearing on behalf of the parties. This appeal has been filed against judgment dated 11/8/2003, within that is decree signed on 22/8/2023. Sorry, judgment dated 11/8/2023, within that is decree signed on 22/8/2023, passed by the District Judge -1 Dhanbad in Civil Appeal number 27 of 2020, affirming the judgment dated 29/11/2017, within that is decree signed on 8/12/2017, passed by the Civil Judge within that is Senior Division that is Close -Roman 3 Dhanbad in title suit number 70 of 2008. The suit arises out of the suit was filed for specific performance of contract. The prayer in the suit is quoted as under. This appeal was admitted by order dated 15th of January 2025. By taking care of the fact that the suit was filed in connection with agreement dated 27/4/2006, read with agreement dated 1/4/2008. But no issue was framed with regard to the agreement dated 1/4/2008. The case was admitted by framing the following substantial question of law. Quote, whether the learned courts could have decreed the suit without framing any issue in connection with agreement dated 1/4/2008. By giving the factual background of the case, the learned counsel for the appellant has submitted that about 98.8 decimal of land was put for auction by Debt Recovery Tribunal in RP case number 170 of 2002. And defendant number 1 and 2 participated in the auction process, and the property was sold was sold at for consideration amount of rupees 10,75,000 for and 2.5 lakhs was already paid by defendant number 1 and 2. For payment of the remaining amount of 8.25 lakhs, the defendant number 1 and 2 were looking for financial help, and the plaintiffs agreed to help the defendant number 1 and 2 to purchase the property in the auction process by lending money, and consequently an agreement of sale dated 24/6/2006 within bracket exhibit 1 was entered into between the plaintiffs and the defendant number 1 and 2 for entire 98.8 decimal of land, and the consideration amount of the property was rupees 19 lakhs. It is an admitted fact that an amount of rupees 8.5 lakhs was already paid by the plaintiffs to defendant number 1 and 2, and the remaining amount was 10.5 lakhs. He submits that it is further not in dispute that 23 decimal out of 98.8 decimal was jointly sold by defendant number 1 and 2 to the plaintiffs by 4 registered sale deed during the period from 18/9/2006 to 6/10/2006, and the remaining property was to the extent of 75.8 decimal and the plaintiffs had and the defendant number 1 and 2 had equal share with respect to 75.8 decimal. He has further submitted that it is not in dispute that कितना था 19.3 lakhs था
Total consideration है वहाँ 19,50,000.
19.5 lakhs लिखिएगा है ना. The learned counsel submits that it is further not in dispute that an amount of rupees 15.21 lakhs was already paid
19,50,000.
and was already paid to the defendant number 1 and 2 by the plaintiffs, and the remaining due was 4.29 lakhs. The dispute arose when the defendant number 2, when the plaintiffs paid an amount of rupees 4.29 lakhs only to defendant number 2, who executed a sale deed in favor of the plaintiffs on 4/10/2007. With respect to the entire remaining property of 75.8 decimal, after deducting 23 decimal of land already sold out of the entire land of 98.8 decimal. He submits that being faced with this situation, the entire consideration amount so far as entire remaining consideration amount so far as 4.29 lakhs was paid to defendant number 2 and nothing was paid to defendant number 1. Therefore, there was a panchayati held in which the plaintiffs as well as the defendants participated, and it was agreed that defendant number 2 would pay 50% of 4.29 lakhs to defendant number 1, and defendant number 1 would execute a deed in favor of the plaintiffs, and on the date of execution of such a deed, the defendant number 2 would pay the 50% of 4.29 lakhs to defendant number 1,
2,45,000.
which comes to rupees 2,45,000. He
At the
submits
time of execution of the sale.
at the time of execution of the sale deed by defendant number 1 in favor of the plaintiffs. Such arrangement was made so that the property which was transferred to the plaintiffs ultimately get transferred jointly by ultimately get transferred both by defendant number 1 and 2.
1 and 2.
He submits that a relinquishment deed dated 1/4/2008 by way of deed of disclaimer was also executed, which was marked Exhibit 3, and then the defendant number then there was an agreement dated 1/4/2008 between defendant number 1 and defendant number 3,
Performer defendant number 3.
and pro forma defendant number 3, which was marked Exhibit 1. The learned counsel has, which was marked Exhibit 1, dated 1/4/2008.
Second agreement.
Sorry, second agreement.
1 by A.
Which was marked Exhibit 1 by A. The learned counsel for the appellant has submitted that in view of the subsequent agreement dated 1/4/2008, the plaintiff had prayed in the suit for enforcement of the agreement dated 24/4/2006 read with agreement dated 1/4/2008.
2008.
The learned counsel then submitted that the learned trial court framed the issues issue number 4, 5 and 6 by only referring to the agreement dated 27/4/2006. But no issue was framed in connection with the subsequent agreement dated 1/4/2008 entered into between defendant number 1 and defendant number and pro forma defendant number 3. प्रोफॉर्मा डिफेंडेंट नंबर 3 का क्या रोल है?
ये इनके नॉमिनी और रिप्रेजेंटेटिव है
He has submitted that pro forma defendant number 3 was the nominee
और
/
रिप्रेजेंटेटिव
representative of the plaintiffs,
plaintiff.
in whose favor the sale deed was to be executed.
Yes.
And the earlier sale deed was also executed in favor of
Several persons.
several persons.
Several persons.
The learned counsel submits that the relief was ex speciae in connection with the agreement dated 27/4/2006, read with agreement dated 1/4/2008, and the learned courts have completely omitted to frame any issue in connection with the agreement dated 1/4/2008. The learned counsel has submitted that in absence of any issue relatable to the agreement dated 1/4/2008, the impugned judgment cannot be sustained as even as per the case of the plaintiff, both the agreements, that is exhibit 1, that is agreement dated 27/4/2006 within bracket exhibit 1 and agreement dated 1/4/2008 exhibit 1 by A were required to be read together. In furtherance to the aforesaid argument, the learned counsel has submitted that no relief as such was claimed against defendant number 2, but the learned court has directed the defendant number 1 as well as defendant number 2 to execute sale deed in favor of the plaintiffs. He has also submitted that no relief was prayed for with regard to cancellation of sale deeds, which were already executed by defendant number 2 in favor of the plaintiffs bearing number 9366 dated 4/10/2007 in favor of Jawahar Prasad, number 9367 dated 4/10/2007 in favor of Janardhan Prasad, and dated 9368 and number 9368 dated 4/10/2007 in favor of Indu Devi and Janardhan Prasad, and 10906 dated 4/12/2007 in favor of Shashi Verma and Ravi Verma, the plaintiffs. And those sale deeds have been directed to be cancelled, and there is a direction for execution of fresh sale deeds in favor by defendant number 1 and 2 in favor of the plaintiffs. He submits that neither the persons in whose favor the aforesaid sale deeds were executed were party in the proceedings. नहीं थे ना party?
नहीं.
Except Shashi Verma and Ravi Verma, who where the purchaser in connection with sale deed number 10906 dated 4/12/2007, nor any relief was prayed for before the court with regard to as against defendant number 2. The entire relief was only against defendant number 1. The learned counsel has also submitted that the learned court has completely, by granting the relief, has completely ignored the impact of the subsequent agreement dated 1/4/2008. Although there are discussions in connection with agreement dated 1/4/2008, but no issue having been framed in connection with the agreement dated 1/4/2008, such kind of relief has been granted. Right? The learned counsel has also submitted that as a consequence of the aforesaid facts and circumstances, the amount of rupees 2.25 lakhs, which was to be paid by defendant number 2 to defendant number 1,
2.45
2.45 lakhs, 2.45 lakhs, which was to be paid by defendant number 2
to defendant number 1.
to the defendant number 1 at the time of execution of sale deed in terms of agreement dated 1/4/2008.
That is deed of disclaimer.
That is deed of disclaimer,
Exhibit 3.
exhibit 3. The same has also not been taken care of. And the sale deeds executed by defendant number 2 in favor of the plaintiffs / their nominees have been set aside, and there is a direction for execution of fresh sale
Yes,
deeds.
sir.
The learned counsel has submitted that had the court taken into consideration the impact of the subsequent deed dated 1/4/2008 and had framed adequate issue in connection therewith, this kind of order would not have been passed by the learned. Okay? The learned counsel appearing on behalf of the respondents.
ये 3 थे. 1 and 2 and 3 sir.
आपको भी कुछ बोलना है? तो बोलना है तो अभी तक तो कुछ नहीं बोले, अभी अचानक कहाँ से हाजिर हो गए?
बैठे हुए थे.
बैठे हुए थे।
पार्टनर है उनके, इसके रिजार्विंग मार्कर उन दोनों में पार्टनर है।
हाँ
और जहाँ तक 4,29,000 की बात है,
हाँ
वो ये लोग दिए ही नहीं है। हमने एक एफिडेविट फाइल किया है।
किन्होंने नहीं दिया है? He is respond number.
Defendant number 1. चक्रवर्ती.
नहीं नहीं, ये तो defendant number 1 is the appellant.
चंदन चक्रवर्ती की तरफ से।
You are for defendant number 2.
3.
Defendant number
नहीं, respondent number 3 यहाँ पर.
respondent की बात करिए, defendant number बताइए।
Defendant number 1 हो जाएंगे. 1 है.
Defendant number 1 तो appellant है।
चंदन चक्रवर्ती.
हाँ, चंदन चक्रवर्ती।
डिफेंडेंट नंबर 2 है लॉर्डशिप.
ये defendant number 2 है।
2.
यहाँ 3।
किन्होंने नहीं दिया है पेमेंट? किन्होंने पेमेंट नहीं दिया आपको?
हम जरा सा पढ़ना चाहते हैं। इसको हम जरा सा पढ़ लेते हैं। ये
बोल नहीं सकते हैं, पढ़ के क्या हो?
ये जो बोल रहे हैं ना कि हमने 4,29,000 दिया है 27/4/2006 को, तो वो सरासर गलत है। और जो मनी रिसीप्ट इन्होंने एग्रीमेंट करवाया है, उसमें मेरा फॉल्स सिग्नेचर है।
बहुत अच्छी बात।
नया बात आ गया. फर्स्ट टाइम.
The learned counsel for the respondent
Respondent 1 and 2.
appearing on behalf of the defendant number 2 who is respondent number 3 in the present proceedings, has opposed the prayer of the appellant. Correct? And he has submitted that the money was not received by him. Was it right? The learned counsel appearing on behalf of the respondent number 1 and 2 representing the plaintiffs has opposed the prayer of the appellant and has referred to Order 14,
Rule 5.
Rule 5 to submit that the court has the power at any time before passing a decree to amend the issue or frame additional issue on such terms as it thinks fit. And court has also the power to strike out any issue that appears to it to have been wrongly framed or introduced. He submits that no prayer was made by the defendant number 1, the appellant herein, at any stage to amend the issue.
Neither by
And-
the trial court nor before
And
the appellate
even
court.
before the learned first appellate court, no such prayer was made. And consequently, such grievance cannot be permitted to be raised for the first time
In second appeal.
in second appeal. The learned counsel has also submitted that as per the deed of relinquishment,
The deed of disclaimer.
the amount was to be paid to the extent of 4.29 lakhs by the defendant number 2 in favor of defendant number 1.
2.45 lakhs.
Okay, sorry, 2.45 lakhs by the defendant number 2 in favor of defendant number 1
At the
at the time of execution of the sale deed in terms of
deed of
the agreement dated 1/4/2008
नहीं,
within
deed of
brackets.
disclaimer.
भाई 1/4/2008 के ही तहत नहीं
हाँ 1/4.
in terms of the deed of disclaimer read with the deed of agreement dated 1/4/2008.
He also admitted the entire consideration amount had been paid.
He submits that in the deed of disclaimer, the defendant number 2 had agreed that the entire consideration amount, that is remaining consideration amount, that is 4.29 lakhs, was paid to him by the plaintiffs and consequently the plaintiffs have paid the entire consideration amount. He submits that there was only a defect with regard to execution of the sale deed, inasmuch as the defendant number 1 could not join at the time of execution of sale deed, and the sale deed was executed only by the defendant number 2 in favor of
Several persons.
the plaintiffs / their nominees, in which the defendant number 1 did not join. In order to take care of this aspect of the matter, the learned trial court has cancelled those deeds which were executed by defendant number 2 in favor of the plaintiffs / nominee, and has directed the defendant number 1 and 2 to join together and execute fresh sale deeds. The learned counsel has submitted that the court has ample power to mold the relief, and such equitable relief has been granted by the court to the plaintiffs. Besides that, Under such circumstances, the impugned judgments do not call for any interference, and the non-framing of issue in connection with the agreement dated 1/4/2008 cannot be, is not fatal to the impugned judgments. However, it is not in dispute from the side of the respondent number 1 and 2 representing the plaintiffs that in the suit there was no relief was prayed to cancel the sale deeds executed by defendant number 2 in favor of the plaintiffs / their nominees, and also the fact that the purchasers arising from such sale deed were not party before the proceedings, except one sale deed which was in favor of the plaintiffs. It is further not in dispute that no relief was claimed by the plaintiffs as against defendant number 2.
One more here, Lordship. In para 39 of the cross examination, and defendant number 1 admitted the deed of disclaimer.
The learned counsel has also the learned counsel has also submitted that in paragraph 39 of the cross examination, the defendant number 3, the defendant number 1 had admitted the deed of disclaimer, which was exhibit 3 before the learned trial. Arguments concluded.
जी.
Post for further dictation.
Lordship.
आप कर देंगे इतना टाइम? थोड़ा सोच के, रिलीफ हमको सोच के बनाना है, ऐसे नहीं कर सकते.
ठीक.
कल हम लिखा देंगे.
जी.
हो सकता है हम लिखा के भी लेकर possible.
ठीक.
कोर्ट में ही लिखाएंगे.
जी.
एक सेकंड जस्ट a moment. लिखिए तो लिख ही लीजिए. After hearing the learned counsel for the parties and having gone through the materials on record, this court finds that on the face of the relief as prayed for by the plaintiffs before the court, the plaintiffs were seeking specific performance of agreement of sale dated 27/4/2006, read with the agreement dated 1/4/2008. 27/4/2006 में within bracket exhibit 1 and 1/4/2008 में within bracket exhibit 1/E. The entire relief was claimed only against defendant number 1, and no relief was claimed so far as defendant number 2 is concerned. This court further finds that no relief was prayed regarding cancellation of any sale deed, and the vendors of the sale deeds which were executed by defendant number 2 in favor of the plaintiffs and their nominee were also not party in the proceedings. It is further not in dispute that the property was purchased by defendant number 1 and 2 in auction sale conducted by Debt Recovery Tribunal in RP case number 170 of 2002 for a consideration amount of rupees 10,75,000, and the plaintiffs had helped the defendant number 1 and 2 to purchase the said property by providing money to the extent of more than 8 lakhs. Consequently, the plaintiffs and defendant number 1 and 2 entered into agreement for sale dated 24/4/2006 for the entire 98.8 decimal of land at the for consideration amount of rupees 19.5 lakhs. The remaining amount which was to be paid by the plaintiffs to the defendant number 1 and 2 was to the extent of 10.5 lakhs. Stop. It is further not in dispute that 23 decimal of land was jointly sold by defendant number 1 and 2 to the plaintiffs / their nominees by virtue of 4 sale deeds executed during the period from 18/9/2006 to 6/10/2006. The entire dispute arose in relation to the remaining area of the property. It has not been disputed that the defendant number 1 and 2 had paid rupees 15. The plaintiffs had paid rupees 15.21 lakhs, and the remaining amount was 4.29 lakhs only. However, the defendant number 2 alone executed the sale deed, different sale deeds in the year 2007 in favor of defendant number 1 and 2 and their nominees in the year 2007, and took the entire balance consideration amount of rupees 4.29 lakhs. So, in plaintiffs or their nominees, plaintiffs or their nominees to the extent of and took the entire consideration amount of rupees 4.29 lakhs, as a result of which the half of 4.29 lakhs, that is 2.45 lakhs, which was the portion of the defendant number 1, was not given to defendant number 1. Consequently, a panchayati was held and an arrangement was made so that the amount of 2.45 lakhs is paid to defendant number 2 to defendant number 1, and defendant number 1 would execute sale deed with respect to his share of the remaining
Both
property
the defendant number 1 and 2 will execute the
jointly. ऐसा नहीं है. Defendant number 1 would execute sale deed with respect to his portion of the
That is
property.
38.5.
That is 38.5
decimals of land.
decimals of land.
Yes.
Exhibit 3 was also executed, which is a deed of disclaimer. This was executed by defendant number? Sorry.
Defendant number 1.
Defendant number 1, name, which was executed by defendant number 2 in favor of defendant number 1. Relinquish कौन किया होगा?
Relinquish नहीं, deed of disclaimer.
Defendant number 1.
1 है.
अच्छा, which was also executed by defendant number 1. In the aforesaid background, the relief was only prayed against defendant number 1 in the trial court. However, the learned trial court, by framing the issue, has completely ignored the fact that the agreement of sale dated 27/4/2006, that the plaintiff was seeking enforcement of agreement dated 27/4/2006, read with the agreement dated 1/4/2008, and the agreement dated 24/4/2006 could not have been seen in isolation.
But there is a discussion of agreement dated 1/8/2000.
Yes, yes. This court finds that the learned trial court, while deciding issue number
5 and 6.
5 and 6, this court finds that the learned trial court, by deciding issue number 4, issue number 4 किधर है? Has held that there was a concluded contract between the parties dated 27/4/2006 with respect to Schedule A property. However, as no issue was framed in connection with agreement dated 1/4/2008 to be read with the agreement dated 27/4/2006, no finding was recorded in connection with the agreement dated 1/4/2008. The learned trial court, by deciding issue number 5 and 6, has
डिस्कस हुआ है.
issue number 4 में तो नहीं डिस्कस किया
इशू नंबर 5 and 6
Five and
डिस्कस है. 12 नोट से निकालिए से. The deed of disclaimer usually agreement to sale dated 1/4/2008, but no such case has been pleaded in written statement. There was a discussion.
Yes.
Internal page 12.
Yes. The learned trial court has recorded a finding that although the entire episode of receiving the balance consideration amount by defendant number 1 and executing sale deeds for the remaining land of Schedule A defendant number 1 तो गलत है ना, defendant number 2 होना चाहिए नहीं. However, the learned trial court has recorded a finding that there was a panchayati held on 30/2008, and in panchayati the defendant number 1 signed a deed of disclaimer wherein he admitted that the balance consideration amount of rupees 4,29,000 was duly received by the defendant number 2 on behalf of both the vendors, that is defendant number 1 and 2, and also admitted that owing to some problem he could not join in the execution of the sale deeds. And then the defendant number 1, by a separate agreement for sale dated 1/4/2008, also agreed to sell his share of 38.5 decimal of land in favor of plaintiffs nominee Janardhan Prasad, but later on he refused to honor the agreement. ये फाइंडिंग है कि इनका वो सबमिशन
Discussion and finding.
Discussion.
ultimately
has discussed finding what has
Page 58
discussed.
में हो जो ultimate
हाँ.
finding. Page 58, issue number 7, para number 7 का concluding.
Yes. The learned trial court, after hearing the counsels and after perusal of the documents and oral evidences, came to a finding that the defendant number 1 had not disputed the execution of agreement dated 27/4/2006, the deed of disclaimer dated 31/3/2008, and the agreement for sale dated 1/4/2008.
There are 7 is also concluding. Now a question there, right? Ending is.
Yes.
Thus,
Just a minute. The learned court also considered the documentary evidences on record and found that as per the deed of disclaimer dated 31/3/2008, within bracket exhibit 3, the defendant number 1 had acknowledged that he along with defendant number 2 had jointly received rupees 15,21,000 out of consideration amount of rupees 19.5 lakhs, and the rest amount of rupees 4.29 lakhs was duly received and acknowledged by the defendant by his partner defendant number 2 Chandan Chakravarti on 4/10/2007. He also admitted that he had received 7,60,000 out of the share. The learned court recorded a finding that it was crystal clear that a valid agreement was entered into between the plaintiffs and the defendant number 1 and 2 on 27/4/2006, and full consideration amount stipulated therein was already been paid by the plaintiffs, and rupees 15.21 lakhs was received by both the defendant number 1 and 2, and the remaining amount of rupees 4,29,000 was received by defendant number 2, which was duly acknowledged by defendant number 1 in the deed of disclaimer within bracket exhibit 3. The finding is quoted as a Thereafter, the learned court recorded that after having agreed to receive the share of money, the defendant number 1 cannot be permitted to take a U-turn and a reference was made to section 115 of the Evidence Act. The learned court held that it was crystal clear that the plaintiffs were ready and willing to perform their part of contract, and in fact they have already performed their part of the contract, and defendant number 1 has not been willing and ready to perform his part of the contract, and therefore the plaintiffs were entitled for a decree of specific performance of contract dated 28/4/2006. While recording this finding, the court again has not given any finding with respect to the agreement dated 1/4/2008 within bracket exhibit 1/A, which was included in the relief portion of the plate. After having recorded that the plaintiffs were entitled for a decree of specific performance of contract dated 28/4/2006, the learned trial court went on to give the relief by posing a question as to when the sale deeds with regard to the land of the share of defendant number 1 was already executed by defendant number 2 and the same was still in existence, then how the defendant number 1 may be directed to execute a fresh sale deed in favor of the plaintiffs or their nominee, that is defendant number 3, with regard to the same land, unless those sale deeds are cancelled, and that too when no relief for cancellation of sale deeds was sought for in the plaint. The learned trial court was of the opinion that even in absence of any relief sought for the cancellation of sale deed exhibit 5 series, the order of cancellation of those sale deeds can very well be passed by the court by way of equitable relief as prayed for by the plaintiff, and ultimately cancel the sale deeds and ultimately suo moto cancel the sale deeds as contained in annexure in exhibit 5 series and directed the defendant number 1 as well as defendant number 2 to execute fresh sale deeds in favor of the plaintiffs or their nominees. This court is of the view that had the learned trial court framed an issue with respect to the impact / enforcement of the agreement dated 28/4/2006, 27/4/2006 within bracket exhibit 1, read with the agreement dated 1/4/2008 within bracket exhibit 1/A. The learned court could have and the learned court, if found that these two agreements when read together were still enforceable and was binding on the parties, then appropriate relief could have been granted. But having not framed any issue in connection with the agreement dated 27/4/2006 read with the agreement dated 1/4/2008, which read with the agreement dated 1/4/2008, the net trial court has committed grave error and has travelled beyond the scope of the suit. The learned first appellate court has also omitted to consider these aspects of the matter, although before the learned First Appellate Court, none of the parties had pointed out that the core issue was relating to agreement dated 28/4/2006, read with agreement dated 1/4/2008, and 27/4/2006, read with agreement dated 1/4/2008, and the agreement dated 28/4/2006 could not be seen in isolation as per the frame of the suit also. The objection raised by the learned counsel for the respondent that the appellant did not raise any objection with regard to the framing of the issues is not acceptable to this court, as it is not only the responsibility of the court, but it is also the responsibility of both the parties before the court, particularly when it comes to the plaintiff, to ensure that proper issues are framed, so that not only the issues are decided, but consequential relief flowing out of such decision is also granted. This court is of the view that the manner in which the learned trial court, this court is of the considered view that the relief which has been granted by the learned trial court is primarily on account of the reason that the learned trial court has completely ignored the impact of the agreement dated 1/4/2008, while holding that the plaintiffs were entitled for a degree of specific performance of contract dated 28/4/2006, and no such finding has been recorded by the learned trial court under the aforesaid circumstances with regard to the entitlement of the plaintiff regarding enforcement of agreement dated 27/4/2006, read with the agreement dated 1/4/2008. Consequently, the aforesaid substantial question of law as framed by this court is answered in favor of the appellant, and the impugned judgments passed by the learned trial court and upheld by the learned First Appellate Court are hereby set aside, and the learned trial court issue यहीं से बना दें,
बना दीजिए।
and the matter is remit होगा कि remand होगा?
Remand है।
Is remanded to the learned trial court to frame
Additional issue
additional issue.
नहीं कर रहा है। With regard to agreement dated 1/8/2000
To frame, to adequately modify the issues / framed additional issue in connection with as to whether the plaintiffs are entitled for a degree of specific performance of contract in terms of a contract dated 27/4/2006, read with the contract dated 1/4/2008. read with करके तो फ्रेम इशू फ्रेम करने से हो जाएगा.
जी
And as to whether there is a binding contract between the parties,
Between the plaintiff and the
amongst the parties, वो हम लोग कुछ नहीं बोलेंगे. Amongst the parties in connection with amongst the concerned parties in connection with the agreement dated 27/4/2006, read with the agreement dated 1/4/2008.
Existing right. What should be existing? Because they have cancelled the service.
वो देखेंगे क्या करेंगे. अगर ये दोनों करते तो दूसरा तरह से रिलीफ दे सकते थे. There was a possibility of
It can be decided in accordance.
that will be decided in accordance.
Saved it because one submission on my part. The judgment cancelling the sale deeds in favor of the
That could not have been. इसीलिए उसको set aside किया.
इसीलिए तो इस पर है कि
जब वो सेट डिसाइड ही हो गया तो
my
खत्म हो गया.
submission is that it's the decree, the judgment of both the courts cancelling the sale deeds of the plaintiff, and in absence of any appeal by the plaintiff before this. That is my submission.
कोई बात नहीं. हम तो जजमेंट से डिसाइड कर दिए हैं क्योंकि आपका
इतना सेल
एक
डीड हुआ खत्म.
इसीलिए बहुत अजीब तरह का जजमेंट कर दिया.
एनी टाइम में भी फिक्स टू
कौन ये पता नहीं चलता.
एनी टाइम में भी फिक्स टू
हम कर देंगे. सब कुछ टाइम फ्रेम कर देंगे. आपको एडिशनल एविडेंस देना पड़ेगा. सब कुछ
हम
करना
देंगे.
होगा. ऐसे थोड़ी होगा.
Both the parties.
कोई अपीयर होने का भी टाइम डेट दे देंगे.
हां अपीयर होने का टाइम.
ठीक है. डेट ऑफ अपीयरेंस भी दे देंगे और कुछ एक एक्सपीडिशियस हियरिंग के लिए भी दे देंगे.
Liberty to both parties to reduce.
Naturally, that is automatic. जैसे ही नया इशू फ्रेम होगा तो लिबर्टी इज ऑलवेज देयर.
या ऑन द रिकॉर्ड जो है उसी पर डेट्स ताकि तो ऑन रिकॉर्ड सिर्फ इशू फ्रेम करेगा और तो कोई गवाही नहीं.
क्या पता क्या गवाही करेंगे क्या करेंगे. We do not know.
और बाकी जो फाइंडिंग्स है लंदन ट्रायल को वो तो खत्म ही हो गई.
वो तो सब खत्म
सब
हो जाएगा. सब
फ्रेश हो गया.
हम लोग बराबर करते हैं मोल्डिंग की रिव्यू.
ये मोल
यहाँ इतना अच्छा मोल्डिंग हो गया 1% मांगे तो 100% मोल्ड
करना ही.
हम लोग रिव्यू के सामने बहस करते हैं तो वो रीड में करते हैं to mold the review. It is a very good example to show that the relief has been diverted and it has been molded to the extent of 99%.
बहुत ज्यादा अजीब तरह से कर दिया. बहुत अजीब तरह से कर दिया. सेल डीड सेट असाइड कर दिया विदाउट पार्टीज. आई जस्ट
Relief ही नहीं मांगे.
just I have nothing to say on this. परचेजर का क्या होगा पता नहीं. परचेजर का हो सकता है कोई उन लोगों का आपस में कुछ एग्रीमेंट हो.
नहीं लोग बेच चुके हैं और हमको आउट ऑफ द कोर्ट जो मालूम है. प्लेंटिफ जो है वो जमीन को बेच दी.
चलो पता नहीं.
हमको पता है हमारा क्लाइंट आया था
हाँ, बताएं हमको.
चंदन चक्रवर्ती से रजिस्ट्री करा के उनको ही बिना आउट ऑफ द कोर्ट उनको भी एक नया पैसा नहीं मिला. जो 4 लाख रजिस्ट्री तो कर दिया. ये अपना क्रिमिनल केस बचने के लिए डिस्क्लेमर भी लिख दिए, पंचायती भी कर दिए, सब कर दिए. उसका लेकिन जो सही चीज है भगवान ऊपर वाला है वही कर दिया. उनका सेल्फ डिटेल कैंसिल.
फर्स्ट अपील. आपका फर्स्ट अपील है.
Notified case item 1. First
Other
of
side है?
2017.
डिफेक्टिव है.
अभी defect is there कि the appellant number name of the claimant number 3 is not does not find in the place and claimant number 5 is not made party. For that purpose, substitution petition has been filed because the actual awardee was Dipti Devi. She
Actual
died.
awardee was.
Dipti Devi.
How do you spell it? कहाँ लिखे हैं?
Now, that's also in the award. Dipti.
आइए फाइल की है.
Five that is IA number 4822.
48.
Two IAs are there, one for limitation and one for substitution.
एक लिमिटेशन. ये तो 5.
Limitation under the flag area and the
Substitution. Yes. Actual awardee कौन है?
Dipti Devi.
Bipti Devi.
Bipti Devi expired, madam.
हाँ.
In her place, her husband Bandhan Bedia came as the appellant. He has also expired, my lord, leaving behind his only son. He died on year 2021. That time his son was minor. Now it's major. So for that purpose, substitution petition has been filed.
तो अभी कौन सब्सिट्यूट होगा?
Shanu
सानू बेदी.
Sanu Bedia.
और अब अपील किसकी तरफ से फाइल की? शानू
Filed
बेदी.
at that time, husband of the deceased wife,
अच्छा.
Bandhan Bedia, but he also died
ये also.
during the pendency of this case.
शानू बेदिया का तो वकालतनामा है रिकॉर्ड पर.
One I is for limitation.
इसी का लिमिटेशन. और आपका डिफेक्ट क्या था?
यही तो वही डिफेक्ट है कि 3 नई प्लेस में एंड 5 इज एडिशनली एडेड.
5 कौन है इसमें?
वही इन प्लेस ऑफ विक्टी देवी एडेड द बंधन बेदी हस्बैंड. For same purpose, 2 defects were shown.
बंधन बेदिया वाज देयर. डिफेक्ट नंबर बताइए.
3 and 5.
Appellant of this case does not find place in CC of the award and 5.
Because Vipti has already.
Applicant of CC of the award was made party in this memo. ठीक है. देखिए. FA number 98 of 2017 with IA number 4844 of 2022. And IA number 4822 of 2022. The learned counsel for the appellant has submitted that IA number 4844 of 22 has been filed for seeking substitution of legal years
Actual
of
awardee.
sole awardee
So, awardee.
named Bipti
Bipti
Devi, daughter of late Gobra Bedia, in LR case number 19 of 2010, who died on 23/11/2016, leaving behind her husband namely Bandhan Bedia, Bandhan Bedia, and one minor son namely Shanu Bedia. He submits that Bandhan Bedia had filed this appeal and he also expired during the pendency of the present
On
appeal
12/8/2021.
on 12/8/2021. The learned counsel submits that office defect number 3 and 5 primarily relates to filing of appeal by Bandhan Bedia as he was not the original awardee. The learned counsel has submitted that on account of death of Bandhan Bedia also, now the appeal has to be pursued by Shanu Bedia. His wakalatnama has also been filed along with the interlocutory application and appropriate order may be passed substituting Bipti Devi and permitting Shanu Devi to pursue the Shanu Bedi. He submits that a petition for condonation of delay in filing the substitution has been filed. He submits that there has been considerable delay, but in absence of any able-bodied person at home, the matter could not be taken up in appeal. He has also submitted that the matter arises out of land acquisition proceedings and a number of batch cases have been recently disposed of by this court. Respondent नहीं है. After hearing the learned counsel for the appellant and having gone through the interrogatory application, the defect pointed out by the office regarding filing of appeal by Bandhan Media instead of Vikti Devi was the sole awardee is hereby ignored as Vikti Devi had expired on 23/11/2016. And the appeal was filed before this court on 10/4/2017 by Bandhan Media, her husband. Considering the fact that Bandhan Media has also expired on 12/8/2021, the prayer for substitution to IN number 4844 of 2022 is allowed, and the office defect number 3 and 5 are ignored. The counsel for the appellant is directed to delete the name of Bandhan Media and insert the name of Shanu Delia as appellant in red ink during the course of the day. However, it is made clear that the substitution has been allowed only for the purposes of pursuing this appeal. And so far as the IN number 4822 of 22 is concerned, having gone through the interrogatory application seeking prayer for combination or delay in filing this appeal, and considering the facts and circumstances of the case, the delay in filing the appeal and considering the fact that the matter arises out of land acquisition proceedings, the delay in filing the appeal is hereby taken. Office is directed to place this case. यही आएगा
Maybe the defect.
और कोई डिफेक्ट है?
No, not really. What case has already been
on
deposited. What case has
Tuesday
also been deposited.
in supplementary cause list and admit करना पड़ेगा ना form में?
Admit करना होगा उसका court fees है.
ऐसे नहीं करेंगे इसको सप्लीमेंट्री कॉज लिस्ट प्लेस करिए, एडमिट करेंगे उस दिन, तब करेंगे इसको। बाकी कोर्ट फीस आपको और भी होगा
इसमें
और कोई डिफेक्ट नहीं बचा। आइए डिस्कस।
Six, we wanted the liberty to withdraw it, right, for the item number 5.
Item 5.
Execution proceedings have concluded, my division.
Essay number 205 of 2016. The learned counsel for the appellant seeks permission to withdraw this appeal. Counsel for the respondent has no objection. Accordingly, this appeal is dismissed as withdrawn. बाकी आप करते हैं
साइन
कौन?
कर दीजिए उसमें।
और भी मीडिएशन वाले मैटर्स हैं ना, कल से आए हैं ना। किसके किसके हैं मीडिएशन वाले मैटर्स? और करिए तो। सीरियल नंबर बताइए।
Item 12, second appeal 8 of 2017.
Item 12. Who is there? Okay.
From supplementary list.
Call करिए के बाद 13.
Item 13, second appeal 14 of 2017. Item 14, second appeal 202 of 2017. Item 15, second appeal 258 of 2017. Item 16, second appeal 262 of 2017. Item 17, second appeal 268 of 2017. Item 18, second appeal 319 of 2017. Item 19, second appeal 440 of 2017. Item 20, second appeal 459 of 2017. Item 20. Item 21, second appeal 515 of 2017.
It may be sent from mediation.
कौन सा सीरियल नंबर?
21 version. Essay 515 or 17.
Other side. Other side से बात किए हैं? Mr. Chanchal Jain. Mr. Chanchal Jain is here. गुरुजी कोर्ट आपको उनको बुला लाइए। 2:15 बजे हम इसको फिर से कॉल करेंगे, ठीक है ना? Any of the matters you are there in any of the matters? This mediation वाला matter में किसी में? Anybody is there? At 2:15 we'll call up these mediation drive matters and we will pass appropriate orders. आप आएंगे दोबारा and inform Mr. Chanchal Jain. सुबह मतलब जल्दी आ जाएंगे तो हम आउट ऑफ टर्न भी करके आपका रेफर